All right, ladies and gentlemen, we are back on the Steve Malzberg show. I want to just tell you a story here as we wait to reach Andy McCarthy, and maybe he could weigh in on this as well because of his time, of course, working in the Justice Department, former U.S. Attorney for the Southern District of New York, a division of the U.S. Department of Justice. I want you to follow me here. Okay, I see we're getting Andy momentarily here. He's up behind you guys. A division of the U.S. Department of Justice was deployed to Sanford, Florida. Okay, we're ready to go? Andy. Hey, Andy. Welcome aboard, my friend.
How are you, Steve?
Good. Andy McCarthy, of course, the author, best-selling author, and his latest one, which is out in paperback, Spring Fever, The Illusion of Islamic Democracy, editor at National Review. You're reading at PJ Media. I got a story here before we get to what we said we'd talk about, just throwing you a little curve. There's a story that a division of the U.S. Department of Justice, which you're well familiar with, and it's called the Community Relations Service, CRS, was deployed to Sanford, Florida last year to provide assistance, apparently, for anti-George Zimmerman protests, including a rally headlined by Al Sharpton, according to FOIA documents secured by an organization. Does this seem right to you?
Well, that they did it, of course, does not seem right.
That's what I mean, yeah.
In terms of, is it likely that these people did it? I think it's absolutely likely. If you remember, Steve, it was Holder who was, I think down there with Sharpton, had a press conference with him, thanked him, just notwithstanding everything we know about Sharpton's background, thanked him for all of his heroic work in the past. And also, I think, and I wrote about this at the time, it was largely because of the pressure that the U.S. Justice Department put on the state of Florida, which I think was really putting its thumb on the scales of justice in terms of threatening a civil rights prosecution under circumstances where there was no evidence, zilch, zero evidence of a federal civil rights violation. But threatening to do that, I think, is what caused Florida to reverse its initial decision not to bring charges. And as we've seen as this case went in, the original decision not to bring charges was a wise one, because it looks to me, I'm frankly, other than the political pressure that explains everything, I'm stunned that this judge has allowed the case to go this far. This case should have been dismissed at the end of the prosecution's presentation.
Yeah, I couldn't agree with you more. And by the way, this is CRS.com. CRS website broke this story, and Judicial Watch, and we're going to have the president of Judicial Watch tomorrow. They made the FOIA request and found out this information. It is outrageous.
Yeah, so just so they don't kill me at PJM, I should note that my colleagues at PJM actually had this about 2 weeks ago.
Oh, okay. Okay, there you go. Well, a drudge link to it today through them. So, but it is an outrageous story, and kudos to PJ Media for breaking that story then 2 weeks ago. I'm glad you brought it up. Okay, let's talk about this McClatchy article that I saw yesterday. Also was linked as a headline on Drudge, with all little excerpts from this story, and basically the Obama plan, the Obama protection plan, if you will, for preventing future Edward Snowdens and future leakers is to have federal workers kind of spy on each other.
Yeah, I think, Steve, that the problem with this story and the way that it's being approached is that it's not such a bad thing that you would have federal employees looking over each other's shoulders with respect to national security information if the government were limited. That is to say, if the federal government were not doing a zillion things, so that spying on each other implied spying on each other for everything, I think you'd certainly be able to not only understand, but support the idea that it should be very hard for people to get access to national security information, and they should be watched carefully with respect to how they handle it. I can say personally that, having gotten a security clearance, which I needed in order to do national security cases, it's a very, very intrusive investigation, and they do a lot of background checks, and they run around and talk to people. It's even more intrusive than getting the job as an assistant U.S. attorney was in the first place, which was also a very intrusive background information. I think most people would say that that's appropriate because in the position I was in at the time, I needed access to national security information in order to do a job that was clearly a federal responsibility and clearly one with respect to national defense information that the public would want protected. I think the problem comes in when you have a federal government that doesn't just do what the federal government was meant to do, but does everything. And therefore, everyone is suspect. And what they're now worrying about is not just national defense information, but run-of-the-mill stuff that should in no way be classified.
Right. Okay, that's fair enough. Yeah, absolutely. Absolutely. But and the criticism of this plan, if you will, from the Obama administration is that there are profiling techniques, which again I think profiling is a good thing, but there are profiling techniques that are unproven, and they fear that they're going to put such a burden on federal workers to look out for against their coworkers, to look for not just obvious suspicious things, but detailed specific things, little things like hours, or looking tired, or going someplace strange on a travel, on a vacation. I mean, every little piece of business. It's almost as if you're charging them with being an investigator or an anti-spy investigator, if you will, someone who in addition to your own duties, it's almost a full-time job to keep an eye on the person at the cubicle next to you or the person across the room from you.
Well, look at it this way, though. I think, again, it's all about context. The military has always had an honor code. They're supposed to report each other for misconduct. That's part of that's part of what the code of the military is. And I think that if we had a situation where somebody leaked important national defense secrets to, say, the Russians, and then we found out afterwards that the guy was taking unexplained vacations, and he seemed to be coming into the office at weird hours of the night, everybody would say, how in the world did those dunderbrains at the federal government let us with that?
Right.
On the other hand, if you're at the Department of Agriculture and it's the clerk who's in charge of the tomatoes division, and he's getting told that he ought to be checking out the guy at the peas division, I think that's where it becomes overkill. And that's a problem of the government being too big more than anything else, I think.
One final question. We have much less than a minute. Alan Dershowitz yesterday said that the prosecutor who brought these charges against against George Zimmerman, Corey, who actually was in court today, should be fired. Do you believe that?
Yeah, I think Alan said that when these charges were brought. I said the same thing. I think this is the most irresponsible prosecution in a high-profile case I've ever seen.
Andy, thank you, sir. As always, great to talk to you, my friend.
Thanks, Steve.
All right, take care. Andy McCarthy, ladies and gentlemen, and check out Spring Fever. It's out in paperback. It's the